Good morning. Thank you for joining me in this webinar where we talk about the employment law changes that have either come into effect or likely to come into effect. Once upon a time, not so long ago, there used to be changes to the law in April and September. When I'm talking about changes to the law, in employment law, changes happen via various mechanisms, but here we're talking about changes to statutes, so say the Equality Act was changing, or changes to regulations like the working time regulations. The idea is that they would happen at the 1st of April and the 1st of September. That's a good idea because it allows both employers and employees to know what changes are happening and plan for those changes. And also, on a much broader picture, it allows the government to look at legislation, prioritise that legislation, look at the changes and see what gaps are being filled and the knock-on effects of changes of legislation. Now that's gone by the wayside for lots of reasons, and what we've seen last year and this year is lots of piecemeal bits of changes of law, so it's harder for people to keep up. So these are the topics that I'm going to run through today, just explaining where those changes have happened and giving perhaps some insight in what that means in practical terms. So one of the changes that has happened is from the 1st of July, fit notes can now be signed by a wide range of medical practitioners, and that could be registered nurses, occupational therapists, pharmacists, physiotherapists. So there is, you're likely to get a fit note, but it may not be signed by a doctor. So the questions I think employers need to ask themselves is, well, how helpful do you find fit notes, full stop? And do you want the company's occupational health or your occupational health provider to take up this role of signing off? I personally am not in favour of that. I think you need to look at what is the role that you want from occupational health. In my view, occupational health should critically, and I do use that word in the sense of objectively analysing, they should critically look at the condition the individual is presenting with, that prognosis, and what treatment they're having. They should also then be able to give a view on what adjustments are needed to get the individual back into work, or what other treatment might be helpful, but that's in the context of them also understanding the role and the business, so that the advice that they're giving to both the employer and the employee is much more useful. It may also be that organisations should really seek about re-evaluating the resource that they have in terms of early intervention, more extensive intervention, perhaps to occupational health or a wide range of specialists, including experts, consultants, because the whole idea is this is to help employees get back to work and to be well. And moves us quite nicely on to, well, you normally get a fit note when there's an absence. You always get a fit note when there's an absence. So looking at the reasons for absence, we've had the Office of National Statistics last year give their annual results, and this is showing that the figures are definitely skewed by COVID, but the first main cause of absence is intermittent illnesses. Then we have always been at number 1, musculoskeletal, which is the back conditions, and then we've all been aware that the mental health issues have been rising, and that's the 3rd largest reason for absences in the UK. And then we have others, which are normally chronic conditions. We're seeing the COVID results in the intermittent, which is not a surprise, and also in the other. The average that the office is reporting for national statistics is 46 days per worker, and people will need to take a view of how that compares within their own organisations. But again, the whole idea of this seminar is to sort of say, looking both at a macro level but also at a wider level, I think organisations need to analyse absences and get to the underlying causes. And it may not be just absences, it may be with hybrid working or working at home. Some absences are being covered up in some way. So this idea of looking at your analytics to really look at what is productivity, what is the outcomes being driven, this idea of the Friday lull, this idea of quiet resignations, is that an issue for your organisation? And what are the underlying causes if it's an issue? Some organisations may have the view that as long as you're producing the work to a high quality, we're really quite flexible of what you're doing, and if that means you take some extra time off on a Friday afternoon, it's not a big issue. But it's up for the organisation to make that assessment. What I would really say is that I would be saying to employers, I would be looking and revisiting your welfare strategies. I am making an assumption that lots of you, and I know lots of you, have really good provision for welfare services within your organisations, that mental health has been on your agenda for a long time, as well as all the benefits you offer. But what I'm sort of seeing is that although at the moment we are genuinely going through a period of national mourning and reflection, before and perhaps after, we've seen constant change, and we've gone from one crisis to another. And so therefore there's these well-worn cliches of having a resilient workforce. But if you'll know your organisations best, the questions you need to ask yourself is there going to be change in the next 6 months? And that might be really positive change, or it may be that there might be a dark winter ahead. And actually, how are your workforce going to react to that? If we've made our people constantly deal with change, that they're in an almost change crisis, then when you're looking at those step-ups for the next change, they haven't got the resilience here. And looking at your welfare provision to say, is it really meeting the needs that are coming? And I would say in the next 6 months, I would put it in that agenda, because what employers, in my view, have is a really good offering perhaps of support and welfare services. And you might need to be shifting your gear so that there is actually active engagement by employees when they realise that there is an issue. And one of the first things on the agenda would be, how do you help employees realise that they may need some help before it becomes an absence issue or a long-term issue? And also shifting of obligation on employees, particularly on mental health, that they are to really actively engage with treatment so that they are not impacted. And again, looking at early stages intervention, how are you going to capture people? How directional are you going to be, which is not normally leads to positive results, but how are you going to get people to sort of say, actually, we are going to deal with these issues, as opposed to people getting themselves into position, then having quite a lot of absence, and employers making lots of adjustments when we could circumvent that if we had dealt with it in an early stage. And perhaps also organisations being very honest and transparent with employees about, this is the consequence of absence or you not engaging in treatment early on. I say this because everything is connected. Welfare and well-being is linked to financial, and with the cost of living crisis, again, it's another reason to revisit the support you've got there and be more proactive, and looking at the nuances and getting people to really engage for their benefit, and making it a real positive message that actually my employer helped me over this little bump early on. So I think those are the kind of things that I would be asking employers to look at. There is a new ACAS guidance on raising issues of discrimination. ACAS gives a lot of guidance, which is useful. That guidance is not law in the sense that employers have to follow it, but the inference can be drawn against you if you don't. So most employers should be using the ACAS guidance, or making sure it's part of their processes, or having a good reason why they've got some exceptions. So the guidance is really about employees asking questions about discrimination in the workplace, and there's some guidance for employers, which I'll also talk about. I welcome this because what it is saying to employees is, look, these are the 6 steps that you should really be doing when you're raising issues of discrimination. I'm sure I'm not the only one that has had seen from the cases that clients have presented, I'm being discriminated, and no explanation for why that isn't, just jumping to that conclusion. So what the ACAS guidance is saying to the employees is that if you've got this concern, you should really identify what is the protected characteristic that you say is being discriminated against. Is it because of what? And also you need to give a factual background of the treatment and the circumstances leading up to it. So we need to know the context, why you say you feel that this may be discriminatory. They are also to put their mind to say, well, what type of discrimination is it? Is it direct? Is it because I am a female that I'm being treated this way? Or is it because actually there's something that the organisation is doing, their custom or practice, which puts me at a disadvantage? Or is it, you are just making these comments and bullying me because I am of a different protected characteristic, or I've protected somebody and I've put my head on the pulpit and supported a complaint? And again, they need to explain why they see that as discriminatory. Sometimes you'll all know that there may be an explanation, but there's been a misunderstanding. But it's like looking at it from the other person's view and say, I can see why you're mistaken, and opening up how that person felt about that. They can ask any additional questionnaires, and here they're saying that the guidance says that they could ask for some statistical information. And so they might be legitimately asking you to sort of say, well, can I have the stats of how many disabled people are in the department, how many women are in the department, how many pregnant women have returned back from maternity leave, or how many pregnant women have been on maternity leave and been made redundant. They can ask for that information. For the equal pay, there is also 3 questions that the questionnaire has to follow. The guidance uses the word questionnaire to describe the employee, and that's identification of their comparator, why the questionnaire thinks that there is a pay differential, and a broad sweep up for other pay related questionnaires. The questionnaires, the employee should ask for a response to a set date. I would say that if it's unreasonable, you can go back and challenge that. It's really people are looking to the substance of their response and whether you use the time wisely to come up with a good answer, because the whole idea of doing this is that it doesn't go further. There's an explanation, there's a resolution, things are sorted. So there is some guidance for employers, but it's actually very short. They do say that employers need to treat the request seriously and deal with it promptly, but that is nothing new. It'd be a very foolish employer that ignored such a complaint, and that in itself, ignoring a complaint of discrimination, would in itself leave questions answered and make the ability to present claims. You're not answering my questions because I've raised discrimination. And then obviously, it's also interesting point is that it's on the employer to follow up with the individual to clarify the question if it considers it's unrelevant and unclear. So again, it's not for the employee necessarily to give us everything, but for the employer to say, I don't understand this, can you explain? That doesn't make sense. Again, no penalty can be drawn, but inferences can be drawn if you don't respond. There is an interplay between constructive unfair dismissal claim. If an employer doesn't deal with this process, it probably would give a right for an employee to say, you fundamentally breached my contract, I'm entitled to resign. And the other thing that I would say is that this is really helpful. You can send this to an employee and say that these are the questions you should consider. Come back to me when you've got those answers, and actually, because it's such a serious matter, I'm going to deal with it under this process, but it's also a grievance, so that we don't have one process followed by another process followed by lots of appeals. We want to be able to do a proper investigation and an outcome and an appeal. You want to have a three stages process. Looking at disability, and in particular long COVID, we've had two cases. In the Mr. Burke case, he was having suffered from long COVID. He was diagnosed with post-viral fatigue syndrome, which impacted him in different ways. And he had attempted to return to work, and then he started a relapse. That fell within the definition of disability. And even though the interesting part from that case, I don't think that's particularly interesting, is that there was no certain date in which the employee would recover. So the employer was dealing with an employee that had a difficult prognosis, and that's more challenging for an employer. And I would be saying that that's one of the reasons that may impact reasonable adjustments and the termination. Another case was a head of people, and I'm aware of my audience, was a head of people who caught COVID just before the dismissal, and she was not deemed to be disabled because it was understandably at the point the decisions were being made, the dismissal, that's when the test applies, and it wasn't long term. She was later diagnosed with long COVID. Mr. Burke obviously had been away for 9 months, so you can differentiate the cases. According to the Office of National Statistics again, there are over 2 million people that are self-diagnosed with long COVID, and they're saying it impacts day-to-day activities, which is one of the definitions of disability, and those are listing the symptoms that people are saying that they are feeling. And in both those cases, there was also this term of brain fog. Again, it links back to my second slide, where I'm talking about your welfare strategy, helping people deal with those kind of issues. But I do accept that the understanding of long COVID is at a different stage as we come to grips with that. Most employers take employees rightly at face value. If somebody comes to you with a medical condition, you deal with that medical condition as if they are disabled, and that will continue. There is, though, we are seeing that when there is a challenge in the courts, there is less concession rightly of somebody being deemed disabled, and there are more cases being seen about actually doing that critical exercise of, does that person meet that definition? There are cases where somebody will say, you have to do this, I'm disabled, without really realising actually disability gives you some rights, but there are things that need to be satisfied, and ultimately an employer, even if you are disabled, makes decisions such as reasonable adjustments and the level of that they can tolerate before it leads to dismissal. We've been involved in recent cases where there was an individual who had two conditions, asthma and anxiety. Generally, asthma, you would think, would fall into the definition of disability. Anxiety is a symptom, it's not a mental classification, so there was always going to be some good arguments on that. The tribunal held in that case at a preliminary hearing, so the case was struck out quite early, that neither of them fell within the definition of disability because of the impact on day-to-day activities, and that was a case that was dealing with mask wearing in the pandemic, so it was of a point in time. Hybrid working, there's new advice released by ACAS in June, which deals with topics, but the advice includes what does a hybrid policy should contain. So many of you had hybrid policies, just checking that they align, how to respond to requests to hybrid working, and obviously the health and safety risks and advice for those working from home. Lots of employers have that and have done that, but it's just worth revisiting. You will remember that at the beginning of the pandemic, when those of us that were lucky enough to be able to work at home, we were just so relieved we could work at home and get that right, that it was seen as that this is the way forward for all working arrangements, and there would be this automatic day one right that somebody could demand to work from home, even though the job may have been advertised as hybrid or office-based or manufacturing-based. There is no legislation proposed. I do not think that that will come in, and in any event, it would have just been on the back of the flexible working arrangements. I think it's quite important for employers and employees to be clear from the outset of their relationship what they expect from each other, and most employers feel aggrieved if somebody signed up for one job application and then very quickly decides they want to change that. What is more interesting, and there is a call for evidence, so employers should be thinking about this. I'm going to be talking a bit later about strikes and collective employee actions. There is a real opportunity for employers to act collectively. There was very good lobbying during the pandemic for industries, and that should continue, and there are lots of mechanisms, and the government is open to that. For that, I am sure. But what they're doing a call for evidence is, for those of you that have hybrid workers, they're looking at the tax and expenses of that arrangement. The current provisions are very complicated in that you may be able to claim certain deductions against taxable income, and they're looking to simplify that. And obviously we have this low level £6 a week that people can make a complaint. It almost seems like the legislation is a little bit behind, in that actually what we are seeing is working practices are evolving, and that is quite right. So hybrid working may be changing for you as we speak, as your organisation is changing, and I think it's important for employers to be really maintaining good evidence of what's good with their hybrid working, what's not so good, and also this bigger picture, which may be that if you're in an organisation which has some hybrid workers but others are not, the imbalance that causes within a workplace. In July, the government published a policy paper, and this is a 10-year action plan to support women, including in the workplace. Our current Prime Minister was Minister of Women, but there won't be such a minister going forward. The whole idea of this paper was to support women in work for issues such as period pains and fertility and endometritis and miscarriages and menopause, and also flexible working. These are all laudable, but I would actually say, well, contrast that with the actual measures that have been implemented. So the government has confirmed it will be not making menopause a protected characteristic in its own right, and nor will they be implementing combined discrimination. So at the moment, the Equality Act does say, there is provision in the Equality Act saying you can bring combined discrimination, i.e. it's because you're in a subcategory of a subcategory. Last week I was doing a defence for a combined discrimination claim, which was for a woman who said she had been discriminated because she was an older woman. So the defence, actually, the first point was that's not in law. So even though it's in the Equality Act, it's not been enacted, it's not in law. You have to prove both the age and the sex, or you just need to prove one. I was quite upset at doing that defence, because she was claiming she would be discriminated because she was an older female, but she was younger than me, and that didn't go down very well. We had the carers leave, which will be 1 week of unpaid. Again, there's no timetable. My general view is that most employers accommodate workers, especially if it's unpaid. So I don't think this is particularly groundbreaking for organisation. We've had last year, or it may have even been the year before, time goes so quickly, we've had a relatively senior Court of Appeal decision which said on indirect discrimination, it's obvious, it's still unfortunately obvious that women have the burden of childcare. So when you were presenting an indirect discrimination claim and you're saying, oh, you know, I'm discriminated because these hours do not suit me and I'm a woman, it impacts more that group, i.e. women, and you would have maybe said statistically, is that right? Are men not doing more of the childcare? And that's certainly an argument that I would have been thinking of presenting, because I am seeing that there is this shift, but the courts are saying probably rightly that it's not there yet. I think we are seeing more men being involved with parental leave, and so hopefully that shift will change, because it's the equalisation at home and other arrangements that impact all aspects going forward, including, you know, equal pay and those issues. There has been an increase in menopause in tribunal cases. So there has been a 44% increase of a low number, 23, and they are falling under disability or sex discrimination or constructive unfair dismissal. And again, I can see that of all of those conditions mentioned, i.e. the period, endometriosis, fertility, miscarriage and menopause, you could see they could fall into those categories. So there is protection there. Most employers do have menopause policies, but again, revisit that with your welfare strategy in terms of what support might be there, and actually what is it that employees want. It would be nice for occupational health to be used not just for absences. I think there might be some really interesting debates to be had about actually the cost of absences and perhaps helping somebody pay for their treatment, and that balancing exercise. So these are things that employers should look at. Firing and rehiring, and I forgot, so I'm going to say it now. I will be taking questions. I may not be able to answer all of them, but I will be taking questions, and I'll leave a bit of room at the end. So if there are any questions, please do let us know, and then Jen will put them to me and I will look blank. So maybe having a shift to the gear and looking at what's been reported and the current climate before we had the current pause that we have, there was lots of publicity on hiring and refiring. We know it as dismissal and re-engagement, and it can be lawfully carried out and has actually been used with really good effect for a very long time. And I'm currently working with employers that will be using this, but in the context that it will not be damaging their reputation. You saw last year that there was a perceived use of this, increase of this tactic with some large employers using it in the pandemic, but there was some misreporting. The P&O ferries was not a case of firing and rehiring, it was just a case of firing. But I would be saying that you will know whether you are likely to make changes in this coming period. And again, it's the bigger picture. How does this pan out for your reputation? Also, we are now coming into the idea of collective industrial action. So your little organisation or your supply chain being part of a much bigger campaign, and that bandwagon, and how are those messages going to get through. Where firing and rehiring is used to really good effect and very reasonably is when you are changing terms and conditions where there needs to be a shift, say, in working hours. So say your client's hours have changed, you might need to respond, and there may be some resistance to that change. And this is a place where you can say, look, actually, these are the demands of our customers, they have changed, we need to now meet those. we need to change your hours. If you don't agree, at the end of that process, ultimately, after our consultation, we will be terminating your current contract, but offering you the same one, except with these changed working hours. Another one might be benefits, in that I can't be the only employer that's getting increase on every single insurance premium that's coming my way. And it may be that you're saying, actually, that's gone up really loads. We're offering you something slightly less, or the ability to top up yourself. That's the change that we're doing, and following that process through. I think using firing and rehiring because you're saying that you're overpaying the employee, that is quite difficult, I would say, to run in the next 6 months because of inflation. Lots of the strike actions is about pay rises. They're not actually saying, so there's that real-time loss because of inflation. So that's what I would say on that. I have put in a slide the actual lawful process to follow and the red flags to follow if you're going to do this. And obviously, most employees generally do agree to the changes, and generally saying to them, look, we're at the end of this is what's going to happen, usually gets the few last people over the line. But this is technically a formal process with the potential for lots of numbers to be impacted, so following that process. But again, because of P&O, there was a massive hoo-ha about this, and up in arms. But what actually has happened? What has the government done on this? Well, they are going to do a new code. That code is not in practice yet, and there's no set date. So actually, nothing much has happened to deal with it. But what they're saying on the new statutory code of practice is that businesses will need to hold fair and transparent and meaningful consultations on the proposed changes to employment terms. That's not new. Can I just say that generally part of the role of HR is to question. Sometimes when we're looking at changes and restructure, there may be an argument that because it's made so senior and so high up in the corporate structure, it is a fait accompli, and that has been a little concern of mine, that actually there's not enough flexibility in the proposal to make consultation meaningful. An employer can run their business as they seem fit, but part of consultation is actually looking at those proposals and the ability to change them in some ways. That the code will contain some practical steps, we'll see what they look like, and then there'll be this uplift of if it's not followed by another 25%, and that's on top of the penalty awards as I understand it. But we will see if that comes into force. But I think there are some learnings that employers can take because of winning the war on the reputational risk. One thing that has come into effect is the use of agency workers in strikes, and we are predicted a winter of discontent and strikes. The old law was that it was actually a criminal offence to provide an agency worker on a strike. So an employer couldn't, if an employee was striking, they couldn't replace that striking worker with an agency staff, nor could they move existing workers, employees, to cover the striking and then backfill with agency. That was unlawful. The new law of since 21st of July is that employers can use agency workers to fill them, but actually that's a bit more problematic because I haven't seen an agency worker driver train, or not aware of one yet. In that employers will still have to consider, well, is that an agency worker? Do they have the skills? Is there some health and safety critical roles that they have to do that we can't train them up on? And against a backdrop of facing real staff shortages. I think, and there's another webinar coming talking particularly about redundancies and strike actions, I think next month that we're running, but this is part of an employer's, again, wider contingency planning about how they may be impacted or their supply chain may be impacted, and how they are using this change of law in a way as part of that contingency planning, along with actually getting their messaging right about why they need to make these changes, why the strike is happening, and the stance that they are taking. Employers, and I say this from somebody who was involved in a strike action where the action was held to be unlawful, but we lost the propaganda war at that time, and that's 25 years ago. But I don't think employers are getting the messages out right, particularly in the context of what we're currently facing. If there is an unlawful strike, then it increases the damages. But going on strike is actually really old law. And the unions are, they have a pivotal part to play, and they get their strike actions more often than not right. So although there's a penalty award, it's difficult to see how that will be really implemented. Employment status now. I do realise that I'm talking as if there are hard times ahead, and I could be completely wrong, but I plan for the worst, plan for the best, and hopefully you'll land somewhere in the middle. And we don't know what next week's budget's going to bring, but we do know what both the Chancellor and our Prime Minister's voting history is, particularly on trusts. So if anyone wants to bet a bar of chocolate, I suspect there will be tax cut for corporates coming next month, and that might fend off some of the concerns that businesses are genuinely facing at the moment. And there may be amendments to the IR35 rules as well, but we wait and see. What we are seeing, and again, this is a balance of the legal system, that the courts also seek to balance out what the government is doing so that there is fairness. And what we are seeing in this EAT case, so it's an appeal case, so a high-up case, is actually when you're determining worker status, what the key question is that individual providing personal service? So even if you have a contract which says we can substitute, anyone to come in, actually, if it's the same employee and you need that expertise, it's looking like he's an employee or she's an employee. If it walks like a duck, quacks like a duck, it's a duck. And they're sort of saying, well, really look at that. Apprenticeships. So there has been a hiatus for lots of reasons, including whilst they choose their own new Prime Minister, and we now have a little hiatus now. But there's changes to apprenticeships. So it's supposed to have occurred in August, but the Minister of Skills resigned during that mass resignation, but we're at the final stages. So I'm talking about legislation that should be passing, and the data protection is one of those as well. And what the focus will be is on a simplification of the system and a much more employer friendly. You have a government that wants to be more employer friendly and are open to persuasion on that. And I think Rees-Mogg, that's his ambit to cut red tape, or it certainly was in his last run. It should be simpler now for individuals to accelerate their apprenticeships. There would be better payment terms or more efficient terms. There is the changing of the maths and English requirement. I'm not so sure that I agree with that, but certainly this idea of having a constant baseline for meeting the criteria of apprenticeships and for the jobs given. What we are seeing as well in April is that there's a pilot scheme of this flexi job apprenticeships, which is 3-month commitment that an employer makes, where there's blocks of training with different employers where they get their qualification. It's currently being used in the creative and construction sectors, but that's an interesting concept to sort of say, is this how we reskill some of our workers? And I would be sort of saying, actually, it might be something really interesting to consider if you are thinking of restructuring and redundancies going forward, actually, looking at all aspects of the relationship from beginning to end, and how we have a dignified, mutually beneficial end to a relationship. Sometimes when we're dealing with issues, what you have is anguish from the employee and such a lot of vitriol because their future prospects are so damaged, or they feel that. And actually this idea of having a flexi apprenticeship is quite a good idea. Also, I'm going to say this and it's going to be recorded, most lawyers learn a lot from their clients, learn a lot more than they impart. And I was really impressed with how employers was using their apprenticeship levies during the pandemic to get additional training for all of their staff across their boards. And so there's just things to think about when you're dealing with some of these issues. And I appreciate you might be a very, very limited resource. Okay, data protection, I'm nearly there. So there has been some changes to data protection. These are the stuff that has come in. We have been deemed an adequate country by the EU. That's such a depressing word, adequate, but it means that we're good enough, that our data regime is good enough. And then there is a new international data transfer agreement and addendum. This has clauses actually contained when there's a transfer of data contracts between jurisdictions. Anything that was in force on the 21st of September 2022, so you have some time, they can remain unchanged until 21st of March 2024. Any new contracts for the transfer of data from the UK after that date will need to use these new contract standard terms. There is a proposal for the data reform bill. Now, this is working its way through government, so it's at the tail end. There may be some adjustments, the Lords might do some adjustments, but actually the data reform bill is creating a new framework which allows people to get their data, but in a responsible way, and having a much more flexible and outcomes approach to databases. It's not going to reduce the 8 principle, it's not going to reduce the burden on keeping data safe, but it will reduce the burden on how employees, the cost of dealing with data, the cost of dealing with subject access requests and all of those kind of things. The key proposals for employers is the data subject access requests. Now, lots of you will have had data protection requests, and you will have got into a regime of doing those data protection requests. Whether you're doing them well enough is another matter, and generally you only find that out if it's linked to a tribunal case, and then you can have a real look at what was disclosed at each stage. But what they're saying on data subject access requests is that there will be this idea that there will be the ability for the employer to say, can you be more specific? They can be a bit more limited. But again, we don't have any details of that. At the moment, you can refuse a data protection request if it's manifestly unfounded. Now we're going to go to terms like, well, if it's vexatious and malicious, and what was the timing of the data? Why are they asking for those kind of things? Again, these are concepts that run in the tribunal system, which have yet to be expanded in data protection. You know, for my clients, you're not going to be the first client that makes, law on that. We will follow what the guidance says because of the consequences of the ICU visiting organisations. There's this idea of using data for legitimate interests more widely. So it may be that you may be able to use your data because you have a legitimate interest. You don't have to ask for consent. Where that might be is if you're giving details to prevent crime or money laundering. So a good example is that if a manager is seeing something happen right in front of their eyes and she whips out her phone and she records it, that would currently fall under one of the exceptions, but it'd be even wider under this, the prevention of a crime or something's about to happen. There's going to be removal of data protection officers and the assessments, but I think in practice they're just going to say you still have to do it, but you have more flexibility in how you do it that meets your organisation better. Having somebody in the organisation that understands data and data protection right from an employee perspective is a very, very important principle, because you know, these are things that again go to reputation and lead to massive fines if an employer is found wanting. I am done. I don't know, Jen, if there's any questions that have come up, and we will, which I'm happy to answer. I just need to.
Hi, Monica. Thank you for that informative presentation. We've had a couple of questions come through, and just to let you know, for all those that have asked if we will be sharing the slides, I can confirm we will be sharing the slides in the next couple of days. So the first question for you, Monica, is: are there any changes afoot regarding workers' status, etc.?
Yes, so I think there's going to be a review of IR35. But what we are seeing in both the tax tribunals and the employment tribunals is this narrowing down of, and more likely to be an employer than not. So we have three statuses at the moment: independent, supplied by somebody else, not one-man company anymore, but you have those independent supply of services, then you have workers, and then you have employees. And workers and employees have some shared rights, such as discrimination and holiday pay, all of those things. And I think that the Taylor reforms are long overdue about the gig economy and all of that. And you'll see that the case law has made it easier for those type of workers to get their rights. And we're seeing in the court's judgment that, you know, this idea that if somebody is providing personal service, if you genuinely, this is going to hurt me, but if you genuinely phone me up and I'm on your helpline, and you might be speaking to me every day, the reality is I'm not an employee of your organisation, because there is a legal identity that is my organisation where I'm employed by or linked to. Also, the advice can be given by another solicitor. However, if you've got somebody coming in every day helping you with a project that is pivotal, and they are saying that they are being provided that they might be able to say that they are an employee, it still remains a very good law, which has not yet been defeated, that if you're provided by a third-party company, that is a genuinely like an agency provision or a third-party employer, that the risk of them being deemed to be an employee of the end user still remains very low. So there are lots of projects where clients are working on that risk factor to do with that. So yes, I do think there are, but I don't know when. I would say that there has been a complete lack of real time and effort spent on employment law changes and working practices. There needs to be the government needs to re-look at this, because otherwise you're finding changes will happen via case law which knock employers off. The working time and the holiday pay is an example of that.
Okay, great, thank you. And the next question, given the Breezel case, can I still defend a claim for annual leave by using 12.07% and stating it on payslips at WTR?
So this is a very, very specific question, and I would need to understand the context of, well, why are you doing that? Why isn't holiday being accrued and paid? There are some circumstances where if you're genuinely a bank worker and you're paying it like, you know, you're genuinely not, you know, you're not working in school, because that was the case where a school teacher had the benefit of a year's holiday, even though working term time, you may be able to get away with that, but it's very small exceptions. And again, I think one of the issues is communication. If you explain to a worker, I'm treating you fairly, I can't do it this way, but I'm doing it this way, look at, this is how I've worked it out, there will be a reason for that. But it really does depend on the industry, the practices, how casual that casual worker really is or bank worker is, and the provision for that. That was a technical question.
And one final question to finish off. Do you think that this change, so I think regarding fit notes, do you think this change to enable pharmacists and others to sign off fit notes will make it easier for some employees to exaggerate symptoms and get signed off work?
Well, that's going to tell what a sceptical person I really am. I will put this in the context of, look, people, you only come to me with your horrible, knotty problems. And, you know, genuinely sickness is genuine, but there will be obviously a tendency for people to get signed off easier. That is the element. And it's not so much the signing off, it's why they're being signed off. What can we do to help them get back into the workplace? But yes, there is the idea that, yeah, you know, if I went and talked to my physio, I reckon I could get a fit note. And there is, and although I made that comment about being offended about my age is catching up with me. You know, I'm sure he would sign me off, but really it may really be helpful, because a fit note, there is a whole section of the fit note where they can say you can work, but you just need to do certain X, Y, and Z. And you know, there seems to be a closing out of that. I think the employer needs to ask themselves a question. If you're going to go through change, or you're going to have some difficult conversations, even if you're going to say to employee, you're not doing that very well, you know, let me help you, let me put, you know, help you with your performance, I'm going to put you on a PIP, or we have to make changes, there are restructuring happening. Will you have a percentage of your employees that will say, no, I'm not dealing with this, I can't deal with this, I'm going to go off ill? So it's those kind of bigger issues that employers need to tackle, and those are the cases that I am seeing where you're seeing people thinking, and demanding that, you know, full payment rights, and demanding that what adjustments have, even though they may not suit the employer.
Thank you. We've got lots of questions still coming in. Should answer them, or have you got time for one more?
Let's do one more, and then you know,
we'll get back to you. Sorry, we can't answer them all. Right.
There's my email. I will pass them out, particularly if you're applying. Of course, I will pass them out.
The last one is, would you consider hybrid working through a whole organisation to be dealt through flexible policy, or just agreement between managers and employees? And then and does that involve a change in contract to include a flexibility clause?
So like that's 6 questions in one. The first part is relatively easy. Yeah. Teams should not be able to agree by themselves their working practices. It's part of a cohesive structure of what suits the team, what suits the organised departments, what suits the bigger picture, because you're creating unevenness and you need to justify that unevenness. There'll be some teams that work and you never see them, you know, but there are other teams where they need to be in, and it may not be to do with the team, it may be training and development of others. So it needs to be both at a team level with agreement of managers, as well as that organisational change level. So that's how I would answer that question. I've actually forgotten what the last bit of the question was.
So is it, and does that involve a change in contract to include a flexibility clause?
So generally, most contracts have some flexibility. The more that you allow a practice to happen, it's going to be custom and practice. But again, this is what I would be saying, that, you know, we've done so many changes to our working practices that we've done so many pivots that we've almost got, you know, the bends, we're flipping and flipping and flipping. But employers are doing the same thing. And actually, this is where you can use changing your terms and conditions really effectively, because what may suit a business this month may not suit a business next month. And the idea as the employer that there is flexibility on both sides. And it could be as cruel as the statistics showing that because of a small percentage of people taking advantage of hybrid working or home working, that everyone has to change. It could be that, but most people will consult about that. I mean, my understanding from some of the advice that the Times has given is that we're all going to be back in the office because to keep our own heating bills down, and you'll be showering here and things like that. We have very nice showers here, but I'm not sure I would use them. I will say goodbye now. If there's any further questions, I hope you found that helpful. I hope one day that we wouldn't need to do this because you will know well in advance in April and September what the changes are. If any of you had the view that you knew all of this, well done, you're doing really well. That's good, but I hope that there'd be some food for thought and some learnings. Thank you very much.